Ghanaian rapper Karani Ayat accused the government of Ghana of misusing his copyrighted works by taking parts of his video and using it without his consent for promotional purposes. This is disconcerting, and it's disconcerting from the cultural IP perspective as well. Cultural IP includes names and symbols and arts and traditional handicrafts that belong to a particular cultural group and are passed down through generations. And so maybe clothing items that are protected, or could be, champagne or Chianti or certain kinds of cheese or basmati rice. What does this have to do with copyright of an individual artist? Well, it's important to protect cultural IP because it's connected to our identity and therefore to our human dignity. But one of the concerns that people raise, and validly raise, is concerns about whether or not any kind of cultural or collective intellectual property right is going to oppress the rights of the individual. And we don't want to oppress the rights of the individual within the group context. And this is why it's important that governments or any official body that is going to be managing cultural IP and cultural heritage shows respect for existing intellectual property. So it's not a good thing that the government of Ghana is accused of misusing an artist's copyright, a Ghanaian artist's copyright. The government needs to make sure that it understands the copyright obligations, that it complies with those copyright obligations of individual artists, because it otherwise feeds into the concern that people have about cultural IP potentially oppressing the individual. If you're not going to respect existing copyright, how do we expect you to manage well the copyrights or symbols, the marks or brands or intangible cultural heritage, cultural IP of the group? Are you going to do it for the benefit of the people? And so I say this, recognizing that one might argue that these are two separate issues, recognizing that they do collide in a way, because we want to expand the IP system to include cultural groups. And any group is going to have to be represented by some official entity. Likely, it's going to be the government. So in the context of Ghana, for example, where they've protected kente cloth under Ghana's copyright law as part of Ghana's cultural heritage, people need to know and have confidence that the Ghanaian government will also respect the rights of individual creators. And this is a delicate balance, it's true, but it's not impossible. Group rights, when it comes to human rights, are somewhat controversial, but we do know how to manage the interests of individuals within a collective. That's what we do in any society. That's what we do in any corporate body. We're managing the rights of the individual within the context of the collective. So cultural IP doesn't need to be oppressive. Cultural IP can be beneficial to individuals, but we don't want to have stories of rappers, musicians, different kinds of creators in countries that are claiming cultural IP. We don't want to have stories of the artists having to make claims of IP infringement against their government. So as we move forward in this cultural IP discussion, it's really important that governments in countries that are claiming that they're rich in cultural heritage, and they are rich in cultural heritage, it's important that they also reflect an understanding of and respect for individual artist rights. I'm Jan from Jotkulture, Cultural Intellectual Property Consulting. Follow me on my YouTube channel to continue the conversation about cultural intellectual property, cultural heritage, human rights, and intellectual property.